Welcome to Ignorantia Legis. It's the 14th of October 2020, episode 22. Salamat sa iyong pag-iuban ka na kung makaigsunan, and I hope you are well. Now, ang atong discussion sa Ignorantia Legis, atong gi-pattern sa bar syllabus. So, episode 22 na ta. Kung naminaw mo na makaigsunan, especially sa YouTube, magbuhat mo playlist dito. Kung maminaw mo na, mura na mo nag-review sa bar. Mura na mo nag-preview for the College of Law. Mura din siya basic discussion sa College of Law. Ang diferensya na sa College of Law na siya oral recitation. But, kung nakaibaw na mo sa basics, sa syllabus, sa discussion, sa topics, na naka-general idea in case studies, makasabot na ka sa argument sa case studies. Right, so, I don't know kung nakadungog ba mo na ko ron o nakadungog ba mo sa background na to. Pero mag-uong kanong sa background. Load ba ang background? Let me see. Okay, sounds very video very okay. Now, nag-discuss na ta sa introductory sa many topics, bar subjects. Ang ato na lang wa pa matagay og introductory discussion ang legal ethics. Arita sa legal ethics ng kaisanan. Karong gabi una, karong gapuna, ma-discuss ta sa legal ethics kung sa oras sa dinyo na naminaw. Again, if you miss some of the episodes, go to YouTube and look for us sa CBAT TV sa YouTube, and in fact, kung gusto mong subscribe, pwede mong subscribe. So, kung mong naminaw di karon, please subscribe to YouTube. Post your comments on YouTube. Kaya kung member na mo sa Facebook. Pero nga sa YouTube kay wa man taon sa YouTube, wa man taon mo wa mo subscribe dito. So kung natay 70,000 sa Facebook, kaya lang nasa tayo 70,000 sa YouTube. Kaya ang monetization ba yan nasa YouTube. Ang Facebook dili kayo klaro ang yung monetization. So ngari ka sa kuan. Okay, si Ma'am Dina Ferrer naminaw na toron. Salamat kay Ma'am sa pagpaminaw og sa inyong kuan. Okay. All right. Okay. All right. So, ngari kita sa naman yun? Ngari kita sa legal ethics. Atong pagdiskusyon ang legal ethics makaigsunan. I hope okay ra mo diha. Okay. Okay lang. Next week. Okay. Sige, ang concept sa legal ethics. Ang coverage sa legal ethics ako nang gi-discuss ninyo. Just may continue. Okay, dan pa. Ay, sakto. That's why I can't hear. Sorry. Mali na ito. Okay, so there are many topics in legal ethics. First, let's go to the practice of law. Concept, definition. Many problems definition ron, ha? This is very important. The practice of law is any activity in and out of court, which requires the application of law, legal procedure, knowledge, training, and experience. It is to give notice or render any kind of service which device or service requires the use in any degree of legal knowledge or skill. Cayetano versus Monsod, 1991. Why is this important? Because Monsod, Christian Monsod, was challenged, I think, when he became appointed to the COMELEC, and the COMELEC requires how many years of practice of law. And then he was questioned because, according to Cayetano, I think again that time was a surgeon or something, or somebody nga nireklamo against Monsod kay ngano kono nga gi-appoint si Monsod nga wa man siya practice of law, but he was a professor of law in UP. So ang problema ron is kung tana GT Benz nag-practice ka og law, ang ilang pasabot di ay kung ning-practice ba ka og law inside the court. And the answer is that is a wrong concept. When you say practice of law, it is any activity in and out of court. It requires application of knowledge of the law. So therefore, teaching law is actually one of the best examples of the practice of law outside court. So that was what was decided by the Supreme Court in 1991. Nga nagtuota nga ang kanilang practice of law, nagtuota nga mukha kas korte. No, that's just practicing in trials, in court hearings, etc. That's just one aspect of the practice of law. So mana siya makaigsunan. No, but Justice Padilla actually dissented in Cayetano versus Monsod. The practice Cayetano versus Monsod. Justice Padilla actually dissented. I don't agree with that dissent of Justice Padilla. In fact, I wrote an article about this, and I have my own definition of practice of law. But according to Justice Padilla, the test is activity, not who or what he or she is. When lawyers teach the law, they are engaged in the practice of law. Their actions as law professors must be measured against the same canons of professional responsibility as the fact of their being law professors is intricately entwined with the fact that they are lawyers. They cannot teach law unless they are lawyers. So this comes from the letter of the UP Law Faculty, Restoring Integrity, as statements by the faculty of the UP College of Law in the allegations of plagiarism and misrepresentation in the Supreme Court. Practice of law is a privilege, not a right. The right to practice law is not a natural or constitutional right, but is a privilege. It is limited to persons of good moral characters with special qualifications duly ascertained and certified. the exercise of this privilege presupposes possession of integrity, legal knowledge, educational attainment, and even public trust, since a lawyer is an officer of the court. A candidate who is morally unfit cannot practice law even if he passes the bar examinations. Manang kantong gipaangkan ninyo niya mo kiha na patay mo, di mo maabogado. Aguirre versus Rama in 2003. While the practice of law is not a right but a privilege, the courts will not unwarrantedly withhold this privilege from individuals who have shown mental fitness and moral fiber to withstand the rigors of the profession. Henry Michael Midado, 2013. In one case, the respondent falsely used complainant's name, identity, and school records to gain admission to the bar. Since the complainant, the real Patrick A. Karunan, never took the bar examinations, the IBP correctly recommended that the name Patrick A. Karunan be stricken off the roll of attorneys. The IBP was also correct in ordering the respondent, whose real name is Richard A. Karunan, be barred from admission to the bar. Grabe, no? Makita ka mga kasuha, makita ka mga legal ethics ng kaso, makaigsoon, makaingon juga. Grabe ng mga tao. In their attempt to become a lawyer, grabe, they'll do anything. The IBP was also correct in ordering that the respondent, whose real name is Richard A. Karunan, be barred from admission to the bar. In this case, the respondent never completed his college degree while he enrolled at the PLM in 1991. He left a year later and entered the PMA, where he was discharged in 1993 without graduating. So, pag yun mo na-discharge pag yun sa 1993 sa bar, sa PMA, ngano ka? Clearly, respondent has not completed the requisite pre-law degree. The court does not discount the possibility that the respondent may later on complete his college education and earn a law degree under his real name. However, his false assumption of his brother's name, identity, and educational records renders him unfit for admission to the bar. The practice of law, after all, is not a natural, absolute, constitutional right to be granted to everyone who demands it. Rather, it is a privilege limited to citizens of good moral character. Karunan versus Karunan in 2016. Bago pa nga kaso. 3 years ago, 4 years, pa mo 4 years. So kanya ba din, he used his brother's name to gain admission to the bar. Profession, not business. Ano mong gigmotiwas ng Mission College mo, Kegson? Kailan ba yan pagkuha college? 1 year ang likuwang niya. Profession, not business. Lawyering is not a business. It is a profession in which duty to public service, not money, is the primary professional but a secondary consideration. Barbie versus Barbie versus Magulta in 2002. Now, in one case, Attorney Ancheta should have advised complainants to accept the judgment of the Court of Appeals and accord respect to the just claim of the opposite party. He should have tempered his client's propensity to litigate and save them from additional expense in pursuing their contemplated action. Instead, he gave them confident assurances that the case could still be reopened and even furnished them a copy of his prepared motion to reopen the case. Despite receipt of the 30,000 pesos acceptance fee, he did not act on his client's case. Moreover, he prevailed upon complainants to give him 200,000 pesos, purportedly to be used to bribe the justices of the Court of Appeals in order to secure a favorable ruling, palpably showing that he himself was unconvinced of the merits of the case. Attorney Ancheta's misconduct betrays his lack of appreciation that the practice of law is a profession, not a money-making trade. Espouses Tolentino versus Ancheta in 2016. Mga bago ni makasuha. Now, what are the qualifications to the admission to the bar? Section 1, Rule 138 of the Rules of Court. Who may practice law? Any person, repeat, any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. So you must be a member of the bar first. Section 2, Rule 138, Rules of Court. Requirements for all applicants for admission to the bar. Every applicant for admission as a member of the bar must be a citizen of the Philippines, at least 21 years of age. Admission to the bar na. So, pwede kag mag-graduate kag 16 years old sa law, pero what kag 21 years old una ka mo bar. Of good moral character and a resident of the Philippines, and must produce before the Supreme Court satisfactory evidence of good moral character and that no charges against him involving moral turpitude have been filed or are pending in any court of the Philippines. So, kung mangilad ka, di ka pasudlon. Manunggab ka og tao, pwede ka makasud. Kaya ang gingon naman diri, no charge against him involving moral turpitude. Kanang mo dunggam ka, o na involved moral turpitude. Requisites for admission to the bar. A. Citizenship. B. Residence. His or her duties to his client and to the court will require that he or she is readily accessible and available. C. Age, at least 21 years old. Maturity and discretion are used in the practice of law. That's why 21 years old. Good moral character. D. Good moral character and no charges involving moral turpitude. The purposes of this requirement regarding moral turpitude are the following. 1. To protect the public. That's why you need moral turpitude. 2. To protect the public image of lawyers. 3. To protect prospective clients. And 4. To protect errant lawyers from themselves. Dantes versus Dantes, year 2004. That's the purpose of having these 4 requirements. Having the requirement of moral turpitude. So, E, for requisites for the admission to the bar. E, legal education consisting of pre-law degree and law proper degree. F, you pass the bar examinations. G, you take the lawyer's oath. And H, sign the roll of attorneys. If you don't sign the roll of attorneys, you are not a lawyer. Passing the bar is not enough. Daghang kay makaso ni makaigsunan. Passing the bar is not only the qualification to become an attorney at law. 2 essential requisites. For becoming a lawyer still had to be performed, namely, taking the lawyer's oath to be administered by the Supreme Court and his signature in the roll of attorneys. Aguirre versus Rama. Legal education. Naglalis ba ng legal education? Pre-law. Section 6, Rule 138, Rules of Court. Pre-law. An applicant for admission to the bar examination shall present a certificate issued by the proper government agency that before commencing the study of law, he or she had pursued and satisfactorily completed in an authorized and recognized university or college requiring for admission thereto the completion of a 4-year high school course, at least 4 years. Karon, 6 years ng high school. The course of study prescribed therein for a bachelor's degree in arts or sciences. A Filipino citizen who completed and obtained his or her Bachelor of Laws degree or its equivalent in a foreign law school must present proof of having completed a separate bachelor's degree. So can you take the bar even if you are a graduate of Harvard Law School? The answer is yes, as long as you are a Filipino citizen when you take the bar. It doesn't have to be naturalized Filipino. You could be it doesn't have to be a natural born Filipino. It is possible that you are an American who become Filipinized by naturalization and you took your Bachelor of Laws degree in Harvard Law School and then you take the bar in the Philippines. That's possible. Law proper. Section 5, Rule 138. Additional requirement for other applicants. All applicants for admission other than those referred to in the 2 preceding sections shall, before being admitted to the examination, satisfactorily show that they have successfully completed all the prescribed courses for the degree of Bachelor of Laws or its equivalent degree in a law school or university officially recognized by the Philippine government or by proper authority in the foreign jurisdiction where the degree has been granted, like Harvard Law School. No applicant who obtained the Bachelor of Laws degree in this jurisdiction shall be admitted to the bar examination unless he or she has satisfactorily completed the following course in a law school or university duly recognized by the government: civil law, commercial law, remedial law, criminal law, public and private international law, political law, labor and social legislation, medical jurisprudence, taxation, and legal ethics. Apil ang medical jurisprudence, dapat naging sa iyong curriculum. A Filipino citizen who graduated from a foreign school, example, Harvard Law School. A Filipino citizen who graduated from a foreign law school shall be admitted to the bar examination only upon submission to the Supreme Court of certification showing A. completion of all courses leading to the degree of Bachelor of Laws or its equivalent degree, like Juris Doctor. B. recognition or accreditation of the law school by the proper authority. And C. completion of all fourth-year law subjects in the Bachelor of Laws academic program in a law school duly recognized by the government. So, mag-agi gyapon kag fourth year di ay. Ikan ka sa Harvard Law School. In bar matter number 1552-A in 2010, the Supreme Court approved the guidelines on the legal apprenticeship program in the Supreme Court and other collegiate appellate courts, allowing qualified fourth-year law students to undergo the legal apprenticeship program at the said courts for at least 160 hours. In administrative matter number 15-04-03 SC Re Letters of Justice Jose C. Vitog, retired, founding dean of Angeles University Foundation School of Law, dated February 7, 2015, and of Judge Avi A. Sorbito Alba, Municipal Trial Court, Daraga Albay. The Supreme Court lifted the prohibition on the accommodation of students to undergo on-the-job training or practicum in the lower courts. So, pwede na po sa lower courts. Now, the Legal Education Board. Di sa tamusugod sa Legal Education Board kaya taas-taas na ng discussion. Yan ay mo, buot pa tag 10 years na discussion natin mga kaigso na. Mura sa tag law school na ni. Hapit na bang oras na to? Magsunod na ba si Angie Sanyel? Anyway, salamat sa pag-uban ka na ako mani legal ethics or have discussed so far practice of law, the requirements, wapata mahuman anak. Interesting ba? If you want to look at our previous episodes, this is the 22nd episode. So go to YouTube. It's easy to look for us there, Ignorantia Legis, and create your own playlist. I will also create my playlist for that. Create your own playlist for Ignorantia Legis, and you can view and you can ask your students, your children, who knows, ma-interested sila para mo take sa bar examination o mo take sa mo go to law school. Okay, so these are the discussions, the ideas I mentioned to you. These are based on the syllabus for the bar examinations. So if we go through all this, pwede na mong bar. October 14, 2020, episode 22, Ignorantia Legis. Thank you and good afternoon. See you tomorrow.